friends, welcome back. In the last session, we learnt about decrees and judgments in detail. Okay, actually, we have to move to the topic of execution, which is dealt by Order 21 of CPC. We will talk about the execution as last topic of our civil practice. Okay, now today we are dealing with reference, review, revision, and appeals. Okay, friends. Normally, in a suit, there will be so many interlocutory applications like Order 1, Rule 10, adding of parties, Order 6, Rule 17, amendment of pleadings, Order 7, Rule 14, document petition, leave petition, seeking permission of the court to file documents, or Order 8, Rule 1A of CPC, defendant seeking permission of the court to file documents, and Order 18, Rule 17, to recall the witness, Order 22, Rule 3 or 4, if the one of the plaintiffs or one of the defendant dies, his LR's legal representatives shall come on record. For that, the parties need to move an application under these rules. Okay, and Order 38, Rules 1-5, arrest or attachment of property before judgment. Order 39, Rules 1 and 2, temporary injunction. Order 26, commission for various purposes, appointment of commissioner for various purposes. And Order 40, appointment of receiver for management of property. Okay, extension of time under section 148 CPC. If the court grants some time and you don't comply that objection, or you don't represent the proceedings within time granted by the court, then section 148 comes into play. Okay, inherent powers. If no provision of the civil procedure code does not deal with a particular aspect, then using inherent powers under section 151, the civil court can pass any order to meet the ends of justice. Okay, this section is used for reopening of the suits. For instance, arguments are concluded and the judge reserved the suit for judgment, but under the plaintiff or the defendant wants to adduce further evidence. In such circumstances, they need to file an application under 151 CPC to reopen the suit. Or if the plaintiff evidence is closed or the defendant evidence closed, then you need to file an application under section 151 CPC to reopen the plaintiff side case or the defendant side case, as the case may be. Okay. These are the interlocutory applications. There will be so many interlocutory applications, but I am just talking about only some important interlocutory applications. Then decree and judgment in suit, and then appellate court decree and judgment in appellate court decrees. Okay, friends, these provisions. And according to these provisions, you have to decide, according to these orders and decrees, you have to decide if you are aggrieved by any of the orders in these interlocutory applications or decree and judgment or appellate court decree and judgment, then you need to resort to one of the modes mentioned in review, revision and appeals. Okay. For instance, if Order 1, Rule 10, party adding petition is dismissed, you need to file a revision. And for instance, if the rejection of plaintiff is rejected or the court makes an order under section 151 CPC, then you need to file the appeal. Okay, and if you feel that the judge has missed something or material evidence, new material evidence came to the light, then you can file review. Okay, and like that. For that, first you need to decide which of these modes you have to choose. Okay, reference is, my dear friends, reference is mentioned in section 113 of CPC and Order 46 of CPC. Reference is if the court comes to a conclusion that the provisions of the government act, regulation or ordinance are invalid, or the provisions thereof are invalid, then it can make a statement and refer the case to the High Court for its opinion, provided that by that time the High Court should not have declared the invalidity of those acts or provisions of law. In such circumstances, the court can make a reference to the High Court for its opinion, for just adjudication of a suit before it. Okay, this is reference. Okay, friends, review. For instance, if any of these orders are a decree of court of first instance, that is trial court, you feel that it has passed erroneous judgment, then you can file a review. Review can be filed in a court which passed the order or decree if the discovery of new material or evidence come to light, and you, after exercise of due diligence, could not place such new material or evidence before the court, or if you feel that there was some mistake or error apparent on the face of record, or for any other sufficient reason the review lies, then you can file a review. Okay, friends, this is review, and review lies when appeal lies, but you have not preferred an appeal. The first circumstance is that. Second circumstance is that no appeal lies against any order or decree. In such circumstances, you can file review. And if the court of small causes court makes a reference to the high court, on that also you can file a review. Okay, friends, this is the concept of review. Okay, friends, revision. Revision is dealt by section 115 of Civil Procedure Code as well as article 227 of the Constitution of India. In criminal practice, revision is concurrent. That is, the sessions judge as well as the high court has concurrent jurisdiction. Either you can move to the session judge or you can move to the high court. Concurrent jurisdiction. Okay, but in civil, on civil side, revision lies only to the high court, whether it is from the order of a junior civil judge, senior civil judge, district judge, etc. Okay, and the revision can be exercised by the high court when no appeal lies against the order which is being filed as revision. Okay, and the high court comes to the conclusion that the the court which passed the order has exercised the jurisdiction which is not vested in it, and the court has, or the court failed to exercise its jurisdiction vested in it, or the court exercised its jurisdiction illegally or with material irregularity, then the high court can interfere with that order under revision under section 115 of CPC. Okay, friends, proviso to revision, section 115 says that, proviso to rule 1 of section 115 says that the high court shall not interfere with the order unless when the order, if it had been passed in favor of the revision petitioner, would have finally disposed of the suit or proceedings before it. It means the order would be in such a way that if it had been passed in favor of the revision petitioner, the order would have finally disposed of the suit or the proceedings before the suit. Okay, the stress is given to the wording, order would have finally disposed of the suit or other proceedings. Okay, if the order is in the nature of final disposal of the suit, then the revision should be filed under section 115 of CPC. In other cases, the revision shall be filed under article 227 to make correction of the order of the trial subordinate courts. Okay, and this revision lies when no appeal lies against the order or decree which is being impugned in revision. Okay, sub rule 3 of section 115 says that mere pendency of revision does not operate as stay unless stay granted by the high court. Okay, and appeals, decree and judgment of the court of first instance, the trial court. Okay, when you are agreed by the decree and judgment of the court, you need to resort to sections 94 to 99 of CPC read with order 41 of CPC, which explains the filing of appeals from the original decrees. That means from the trial courts, original courts, with courts of first instance which pass the original decrees. Okay, friends, this in certain circumstances there will not be any appeal. For instance, if the decree is passed with the consent of the parties, that is compromise decree, then no appeal lies. And another circumstances is when the against the decree of a small cause court, the value of which does not exceed 10,000, except when a question of law is involved. In such cases, the decree of the small causes court cannot be appealed. Okay, friends, and appeals from appellate court. Actually, appeals from original decrees are called the appeal suits or first appeals, and appeals from appellate court decrees are called the second appeals. Okay, the second appeals deal with sections 100 to 103 CPC and Order 42 of CPC. Okay, and no separate procedure is contemplated for second appeals, and Order 47 says that the provisions of Order 41 which relate to the appeals from original decrees apply to the second appeals. Okay, friends, and second appeal lie only when the substantial question of law is involved in the second appeal. Merely because the facts are not appreciated by the court properly, then no second appeal lies. Unless you show to the satisfaction of the High Court that question of substantial question of law, not mere question of law. The question of law should be a substantial one, which is to be adjudicated in the second appeal. Then only the second appeals will be admitted and will be adjudicated. Okay, and the first appeal and the second appeal, how where they can be filed, depend upon the pecuniary jurisdiction of the appellate courts. For instance, an appeal from a decree and judgment of a civil judge will lie automatically to the district judge, and the appeal against the decree and judgment of a district judge will lie before the Honorable High Court. Okay, and the decree of subordinate judge sometimes appeal against the decree of subordinate judge sometimes lie to the district judge and to the High Court according to the pecuniary jurisdiction of the suit decided by the subject. And further, the appeals from the subordinate judges, that is senior civil judges court, decrees from the senior civil judges court, or the decrees from the district judges court will be dealt by a division by two judges according to the pecuniary jurisdiction of the suits decided by the senior civil judges or district judges, and you can refer your state's civil courts act for these provisions. Okay, friends, this is first appeal, this is second appeals, and friends, the last one is appeals from orders. Section 104 to 106 CPC and Order 43 CPC deal with the appeals from the orders. For instance, if the court passes an order in the interlocutory application, for some of these orders, appeal lies, not the revision. Okay, and in Rule 1 of Order 43, it has been clearly mentioned against which orders the appeals lie. Okay, friends, appeal lie to the appellate courts automatically. Okay, for instance, if the junior civil judge passed an order in an interlocutory application and such appeal is appealable, then the appeal shall be filed before the district court. Likewise, if the order passed by the senior civil judge is aggrieved, you should file an appeal before the district court or the High Court according to its pecuniary jurisdiction. Okay, these appeals from orders are called civil miscellaneous appeals. Okay, friends, this is how these appeals work. Okay, friends, after passing orders, first I recommend you you see that whether the order falls within the category of Rule 1 of Order 43 to file an appeal against the order of the trial court, not decree, against the order. Okay, if you feel that CMA lies, civil miscellaneous appeal, then file civil appeal. After going through the Rule 1 of Order 43, if you come to a conclusion that CMA does not lie, revision lies, then again you have to see that revision has to be filed whether under section 115 of CPC or under article 227 of Constitution of India. Okay, friends, or if you feel that review is maintainable in any case, if this criteria is applicable, then you can file a review also in orders also, not only in decrees, in orders also. Okay, friends, for instance, a rejection of plaint or an order made under section 151 of CPC are equal to a decree, are included in the decree as per the definition of decree in section 2 subsection 2 of CPC. Therefore, against those orders only first appeal lies. Okay, friends. Here, when an appeal is preferred before the first appellate court against the original decrees, that court has so many powers, and one of those powers is remanding the suit back to the trial court for adducing further evidence, etc. That is also called decree. But as per Rule 1, Clause U of Order 43, a decree of appellate court remanding the matter back to the trial court for any action that becomes an order, and only CMA lies, not the second appeal. Okay, normally against the decrees of appellate courts, second appeal lies, but here is the exception. If the appellate court remands the matter back to the trial court, then CMA lies, not the second appeal. Here are the orders, but these orders will become decrees and you have to file the first appeal. Okay, friends. One more thing, in execution petitions like Order 21 Rule 58 CPC or under Section 41 CPC, during the execution petition, if third party comes and file a claim petition and the court decides that claim petition, then no revision, only appeal lies. Okay, that order passed by the executing court shall be treated as decree for all purposes, for all practical purposes, and only the appeal lie, not any revision or review. Okay, friends, that's all for now. Thank you.